All right, so I'm gonna give you a quick rundown of what happened this year, and with my twin daughters. I ended up having to file one, two, three, four appeals. I think it was. While I was fighting a case, it was dismissed for lack of proof. On motion of the people. And I was in custody for, I think it was 93 days before they dismissed it. And they dismissed it the day before trial. There's the trial date, the 7th, and they dismissed it on the 6th. That seems to be how they usually do it. When they don't have a case, they just try to wear you out, basically. This is all the clearly established law at the time. But we're going to go with here. This was part of the appeal. I wrote 45 pages by hand. And then my attorney, Tim Tui Tavuki, is pretty good. 209-481-2497. If you're in California, give him a call. He's a good defense attorney. He stood up to the judge, filed a preemptory challenge, dismissing the judge as prejudice. And he told me that I need to continue on with my bar degree, that he's met jailhouse lawyers, and I'm not a jailhouse lawyer, I'm a real lawyer. He had confidence in my legal skills, and he told me that I was basically being held with no bail for the reason of my legal reputation in Amador County, because Calaveras County and Amador County, they're right next to each other. They share a public defender's office. So, and then the DAs also go back and forth. One DA will work. They can't actually share DAs, but one will go and work for Amador, or the other will go and work for Calaveras, and they'll just switch jobs. So on April 28, 2024, I left an abusive relationship and relocated with my twin daughters, whom I had custody of. And that's Family Code Section 7501 and In Re Burgess, 1996. This is all the case citation. It's a presumptive right to change residence, entitled unless move is detrimental to the child. And then in remarriage of Figert, 1990, parents' right to resettle, or custodial parents' right to resettle, find new employment, and start a new life without losing custody of the child. Broadly encompasses the constitutional right to travel. On April 29th, 2024, I contacted Miss Baker, who was the Calaveras County Social Services, by email, informing her of the relocation of the twins and I. And then I informed her of the reason to relocate was for the domestic violence against me, and that the twins' mother inferred something or someone might harm the twins if I didn't leave the vehicle with her. On April 29th, the twins' mother texted me. I've requested a custody hearing to be executed on Wednesday, May 1st, 2024. No address nor copy of the complaint, as well as not served by a person who is not a party to the action. 2 days notice. So I wasn't even served the summons, and they still proceeded. Not served the summons nor the complaint. On April 30th, 2024, being unable to stay with my mother at my brother's house in Gridley for the reason my brother did not want drama, we relocated to my sister's house in Utah. On May 1st at 5:20 a.m., we settled at my sister's house in Utah. The twins had diapers, new clothes, toys, sippy cups, and food, and I had receipts showing that we were in Utah. On May 2nd, 2024, I made an appointment with Ken Walker, a family law attorney, and we discussed things. I have his notes. I had he didn't understand how she even got a court order without me ever being served anything. On May 2nd, 2024, twins' mother hacked into my phone account in the store with the in-store visit at Cricket Wireless and turned my phone line off. So she turned my phone line off and then sent me another message saying that I had court. On May 2nd, twins' mother texted me, I am requesting a hearing for Calaveras County in San Andreas for tomorrow morning at 11 a.m., 5/3/2024. Again, there's no address nor copy of the complaint, as well as not served by a person who is not a party to the action. Less than 1 day's notice. Proof of service on file, or no proof of service on file. And this is against California Family Code Section 3408. The Federal Code 28 USC Section 1738A, E, and Federal Code 25 USC Section 1912. It's a ICWA notice because our children are American Indian children. And so ICWA applies because we've been recognized. I'll go more into depth with that. And then on May 3rd, 2024 at 11:15 a.m., I met with Mr. Walker to draft up a protective order and a parenting plan agreement. I was trying to be amicable with her and share custody, and things got out of hand with her, and she lied in order to get this thing going. Her cousin works for the sheriff's office, Calaveras County Sheriff's Office, and I think that's how things were sped up, because she got a court order within 3 days, and they have to give me 15 days to respond. Or at least 10 days. On May 3rd, 2024 at 11 a.m., Judge David M. Sanders granted an ex parte temporary emergency custody order terminating all my parental rights with no visitation in violation of the Uniform Child Custody Jurisdiction and Enforcement Act, the Parenting, or Parental, it's supposed to be Parental, Kidnapping Prevention Act, and the Indian Child Welfare Act, and the California Welfare and Institution Code. Those were also violated. Family Code Section 3424. This is what he was operating on. Unsubstantiated allegations are insufficient to invoke emergency jurisdiction. Juvenile court erred in holding jurisdictional and dispositional hearings When a child cannot be found, temporary emergency jurisdiction cannot be invoked in the absence of proof of the child's whereabouts, even if the juvenile court believed the mother's testimony. That's in re Baby Boy M, California Appellate Court, 2nd District, 2006. The case citation there. The rest of the case citation. And then Family Code Section 3408. The requirements of due process of law under U.S. Constitution 14th Amendment are met in a child custody proceeding when, in a court having subject matter jurisdiction over the dispute, the out-of-state parent is given notice and an opportunity to be heard in a manner provided. See in remarriage of Leonard, California Appellate Court for the 1st District, 1981. And the rest of the citation, the court departed from the procedural requirements of the Uniform Act by giving a 3-day notice of the proceedings rather than the 10-day notice required by the Uniform Act for the exercise over persons outside the state. See Allison versus Superior Court. That's California Appellate Court, 2nd District, 1979. And then Family Code Section 3402, a tribe, P. That's 3402P. A tribe means an Indian tribe or band or Alaskan Native village that is recognized by federal law or formally acknowledged by a state. We fall under both. If you look at my other videos. And then Family Code Section 3404. And because we were already in proceedings, she had agreed to proceedings with the tribal council. She actually initiated it. So a child custody proceeding that pertains to an Indian child as defined in the Indian Child Welfare Act is not subject to this part to the extent that it is governed by the Indian Child Welfare Act. A court of this state shall treat a tribe as if it were a state of the United States for the purpose of applying this chapter and Chapter 2. A child custody determination made by a tribe under factual circumstances in substantial conformity with the jurisdictional standards of this part must be recognized and enforced under Chapter 3. Full faith and credit. Okay, and then this is the PKPA 28 USC 1738A. And then this is C, Part C. A child custody or visitation determination made by a court of a state is consistent with the provisions of this section only if 1. Such court has jurisdiction under the law of such state. And that's right here, under the law of such state. So this is how we're tying in the federal right here, and it's family codes that we just cited, section 3402P and 3404A, B, and C. And then the citation, Cherokee tribe is state, as defined under the PKPA 28 USC section 1738A, B, 8, and is entitled to the benefits conferred by act, and subject to its obligations. See Henry Larch. That's 4th Circuit, 1989. And then number 2, one of the following conditions is met. Such state, 1, is the home state of the child, and 2, had been the child's home state within 6 months and the child is absent from such state because of his removal by a contestant or for other reasons, and the contestant continues to live in such state. So that right there, that's an inference that you're allowed to relocate And then Part D, the jurisdiction continues as long as the requirement of subsection C1 continues and such state remains the residence of the child or of any contestant. And then C or E, excuse me, before a child custody or visitation determination is made, reasonable notice and opportunity to be heard shall be given to the contestants. So not only notice, but you have to be heard. So in CCP section 187, they try to say that a judge doesn't have the power to, or has the power to not hear you, which is they need to statutorily get rid of that court decision and just squash that, because that's ridiculous. Everyone should have an opportunity to be heard, but this is federal law, so you have to be heard, not just them make you show up and then not even giving you an opportunity to speak. And then California did not have continuing jurisdiction under Section 38AD since prior California custody decree was made without notice and opportunity to be heard as required by Section 1738AE. So no jurisdiction. And that's a State v. Carver. That's a Washington decision. And it was modified. And then California ex parte order directing return of child to mother was not entitled to full faith and credit under PKPA, since father and mother had equal right to out of wedlock child prior to initial custody determination. Father could not be deprived of custody without reasonable notice and opportunity to be heard. Our facts fall right into that. See Sherry and F versus Bennett's, and that's a New York case. And then ex parte temporary custody order was, I left out, not entitled to full faith and credit under PKPA, since neither mother nor grandmother were served any legal process or afforded any other notice or opportunity to be heard. Joel M. versus Karen M. It's another New York family court case. And then this is an unpublished decision. So I got all these out of the annotated section 28 USC section 1738A from the legal research that was in the jail, because I always do all my own law work. I don't really depend on the lawyer. Only an idiot would depend on a lawyer and not do their legal research and assist the attorney, because then you can't utilize barcode 1.2, where you're the one that is controlling the aspects of the case. So actual notice without any attempt at service of process is insufficient to satisfy a requirement of 28 USC Section 1738AE that reasonable notice and opportunity to be heard of pending custody proceeding be given to person having physical custody of the child. And that is an Alaskan case. And then ICWA is 25 USC section 1912. If the court has reason to know that the proceedings involve an Indian child, it has a duty to give the required notice itself. And then these are all the cases that are citing that. Notification requirements were triggered when mother indicated she might have Navajo heritage. And then that one's and then this one is Henry Gabriel G. 2012, like me, Gabriel G. What's up? Child's birth certificate triggered application of ICWA by designating Indian father as child's biological father. This duty is sua sponte because notice is intended to protect the interests of Indian children and tribes despite parents' inaction. The notices, return receipts, and responses of the BIA and the tribes must be filed with the court. And that's a California Rule of Court 5.482B. And then there's the case that backs it up. All responses must be filed. The court may not rely on mere representation that proper notice was given. There must be a court record of the notice documents in the case. And then this one, section 1914. When proper notice is given under the ICWA, a court's order terminating parental rights, or a proper notice, when a proper notice is not given under the ICWA, a court's order terminating parental rights is voidable. So you have to file the petition. For instance, a court of appeal has reversed a termination of a mother's parental rights because the state failed to provide a tribal nation with proper notice of proceeding, including accurate information pertaining to all known direct lineal ancestors, which may have altered the results of the hearing. And because we're our lineal ancestors with Goyakla, which is known by the as Geronimo, that should pertain. And then juvenile court termination of parental rights conditionally reversed and remanded because of ICWA notice violation. Court of Appeals rejected county's argument that the only remedy parents had was a petition for invalidation at the juvenile court level and not the appellate level, and that the parents did not have standing as non-Indian parents. So they rejected that argument. Notice must be sent to all tribes of which the child may be a member or eligible for membership. The notice must include the names of the children's ancestors and other known identifying information and be sent by registered mail, return receipt requested. Oh, that was the other thing. So the courts over in Utah, they only gave a 1-day notice, but then they're also sending certified mail. And the mother of my daughters is the one that's answering it. Like, these people just boggle my mind with with how they operate, just completely out of line. If the identity or location of child's tribe cannot be determined, notice of the proceeding need only be given to the Bureau of Indian Affairs. No proceeding involving the custody of an Indian child may be held until at least 10 days after receipt of notice by the child's parents, Indian custodian tribe, or the BIA. So they have to, it's not until 10 days after they receive the return receipt can they have a hearing. If a party knowingly and willfully falsifies or conceals a material fact regarding whether the child is an Indian child or counsels a party to do so, that person is subject to court sanctions under the Welfare and Institution Code, section 224.2E. And then section 25 USC, section 1912. When termination of parental rights is sought, the evidence, including expert testimony, must establish beyond a reasonable doubt. So for ICWA, it's beyond a reasonable doubt that the continued custody of the Indian child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. This finding can be made at the hearing, at which the Welfare Institution Code section 366.26 hearing is set, thus meeting the federal requirements under 25 USC section 1912 in the case that backs that up. But California has added its own statutory requirement that requires the findings supporting the termination of parental rights to be made at the hearing terminating parental rights. So that's kind of what I like about California. They've added extra protections to ICWA. Congress intended to give Indian tribes access to federal courts to determine their rights and obligations under Indian Child Welfare Act. And the case for that one out of the Ninth Circuit. Okay. On May 3rd, Judge David M. Sanders made a false and misleading statement on the Form FL 341B, saying that I has violated or threatened to violate a custody or visitation parenting time order in the past. This is the order that he just made, and he's saying that I have a history of violating the order, has a history of not cooperating with the other parent or part.